There is a version of history where Guglielmo Marconi is simply the man who invented radio. It is clean, it is satisfying, and it is, according to the United States Supreme Court, largely wrong. The 1943 ruling in Marconi Wireless Telegraph Company, United States, did not just invalidate a patent. It cracked open one of the most celebrated origin stories in the history of technology, and in doing so, it pulled 3 other names out of the footnotes of science and placed them where some argued they always belonged, at the center of the story. To understand how a Supreme Court case could upend decades of received wisdom, you have to go back to the 1890s, when the race to harness electromagnetic waves was not a single man's triumph, but a frantic, overlapping, sometimes furious competition between some of the sharpest minds in the world. Guglielmo Marconi was, by any measure, a formidable figure. Born in Bologna in 1874, the son of an Italian landowner and an Irish mother, he was restless, ambitious, and possessed of an extraordinary instinct for turning scientific theory into practical apparatus. By his early 20s, he had built a wireless telegraphy system capable of transmitting signals over short distances. By 1901, he claimed to have sent a signal across the Atlantic Ocean. The world was dazzled. Marconi was a genius of engineering and, perhaps just as crucially, a genius of self-promotion. He understood that in the modern era, the person who filed the patent and captured public imagination was the person history would remember. He built a commercial empire. He received the Nobel Prize in Physics in 1909, sharing it with Karl Braun. He was decorated by governments, celebrated by newspapers, and treated as the singular architect of wireless communication. The patents were the backbone of all of it, and the patents, it would eventually turn out, were the problem. Patent law has a concept called prior art. Simply put, you cannot patent something that already exists in the public domain. If someone has already described, demonstrated, or published the key principles behind your invention, your claim to exclusive ownership collapses. What the Supreme Court found in 1943 was that Marconi's most important patents, the ones that form the commercial and legal foundation of his wireless empire, were built on principles that other scientists had already established, described, and in some cases demonstrated before Marconi filed his claims. The 3 names at the heart of this finding were Nikola Tesla, John Stone, and Oliver Lodge. Each of them had contributed something fundamental. Together, they had essentially mapped the terrain that Marconi later claimed as his own discovery. Nikola Tesla needs no introduction to most people, though the full scope of his contribution to radio is still underappreciated. By the mid-1890s, Tesla had been working extensively on the transmission of electrical energy through the air. He had developed and patented systems involving resonant circuits, the principle by which a transmitter and receiver are tuned to the same frequency, allowing for selective, coherent communication rather than the indiscriminate blast of energy that earlier wireless experiments had relied on. In 1897, Tesla filed 2 patents in the United States, covering a system of wireless telegraphy that used tuned circuits operating at the same resonant frequency. These patents predated the key Marconi patents on the same subject. The United States Patent Office, in fact, initially granted Tesla's patents and rejected Marconi's application on the grounds that Tesla had already covered the relevant ground. Marconi applied again. He revised his claims. And in 1904, in a reversal that has never been fully explained to most people's satisfaction, the Patent Office reversed itself and granted Marconi the patent. The turnaround has long been a source of suspicion. Marconi by that point was wealthy, well-connected, and backed by investors with deep pockets. Tesla, by contrast, was in financial ruin. He had burned through his backers' money on ambitious projects, his great Wardenclyffe Tower project was collapsing, and he had neither the funds nor the institutional support to fight the reversal aggressively. The Patent Office's about-face stood, but it did not disappear. It became the foundational crack in Marconi's legal fortress. Oliver Lodge was a British physicist of considerable standing, known for his work on electromagnetic radiation and his meticulous experiments following on from James Clerk Maxwell's theoretical framework and Heinrich Hertz's experimental confirmations. Lodge delivered a famous lecture in 1894 at the Royal Institution in London, just months after Hertz's death, in which he demonstrated the transmission of Morse code signals wirelessly across a room. This was a landmark demonstration, not incidental background noise. More importantly for the legal case, Lodge had developed and patented a system he called syntonic tuning, which allowed a transmitter and receiver to be matched in frequency so that communication could be directed and selective. His 1897 patent on this system was explicit, detailed, and clearly prior to Marconi's later claims on similar techniques. Lodge knew his ground. He had written about it, spoken about it publicly, and protected it legally. Marconi's defenders would argue that Lodge's system was theoretical or impractical at scale, but the court was not asked to decide who built the better system. It was asked whether the underlying principles had already been disclosed to the public. They had. Lodge had put them there. John Stone, and yes, that was his actual name, is the least famous of the three, which is itself a kind of historical injustice, given the precision and sophistication of his work. Stone was an American electrical engineer who filed patents in the United States in 1900, covering a comprehensive system of wireless telegraphy that described tuned circuits, selective transmission, and the methods of adjusting receiver and transmitter to operate on a common frequency. Stone's patents were detailed technical documents, not vague gestures toward a concept. They laid out with engineering specificity the architecture of wireless communication in ways that overlap substantially with the Marconi patents that came after them. Stone himself spent years arguing that his contributions had been absorbed into the Marconi empire without credit or compensation. The Supreme Court ultimately agreed that his work constituted legitimate prior art that Marconi's patent claims could not override. The case that reached the Supreme Court in 1943 had its roots in a dispute between the Marconi Wireless Telegraph Company of America and the United States government. During the First World War, the U.S. government had commandeered numerous wireless patents for military use, standard wartime practice. After the war, the Marconi Company sued the government for patent infringement, seeking substantial compensation. The government's defense was blunt. You cannot infringe patents that should never have been granted. The government argued that Marconi's key patents were invalid because the inventions they claimed had already been disclosed by Tesla, Lodge, and Stone. This was not a peripheral argument. It was the central one. By 1943, Marconi himself had been dead for 6 years, having died in Rome in 1937 following a series of heart attacks. Tesla, extraordinarily, was still alive when the case was argued. He died in January of that year, in a room at the New Yorker Hotel, almost entirely broke. He did not live to see the ruling. The court handed down its decision in June 1943. The ruling, written by Justice Owen Roberts and joined by a majority of the court, was sweeping in its dismissal of Marconi's claims. The court found that Marconi's patent number 7637726, the key patent on the four-circuit tuning system that Marconi had long claimed as his great innovation, was invalid. The prior art from Lodge and others had already disclosed the essential elements. The government did not owe the Marconi Company compensation because the Marconi Company had not held valid patents to infringe. It would be too simple and actually inaccurate to conclude from all this that Marconi was a fraud. He was not. What the court found was not that Marconi had invented nothing, but that the specific patents at issue claimed ownership of principles that others had already put into the public domain. This is a meaningful distinction. Marconi's genius was synthesis and execution. He took existing components, refined them, combined them, and, crucially, built working commercial systems that transmitted signals across real distances and real conditions. He pushed wireless communication out of the laboratory and into the world. That is not nothing. In many respects, it is everything when it comes to the practical development of technology. But patent law does not reward synthesis and execution when the components being synthesized are already protected or publicly disclosed by others. The law rewards the person who first discloses the novel idea. And on that narrower but legally decisive question, the court found that Tesla, Lodge, and Stone had been there first. What makes this case so persistently provocative is what it reveals about how technological credit gets assigned in the modern era. Marconi built an empire on patents and publicity. Tesla built extraordinary things and then watched them be absorbed into other people's commercial victories. Lodge was a respected figure within British science but never achieved the celebrity that his contributions arguably warranted. Stone was, for most of the 20th century, almost entirely forgotten. The mechanisms that determine who gets remembered are not purely scientific. They are financial, political, and cultural. Marconi had backers. He had a company. he had a talent for the press. He operated in an era when wireless telegraphy was simultaneously a commercial product and a public spectacle, and he understood how to position himself at the center of both. Tesla, for all his brilliance, was erratic in his business dealings and catastrophic with money. Lodge was British and academic in a field that was increasingly being shaped by American commercial interests. Stone had neither wealth nor fame to amplify his claims. The 1943 ruling could not, of course, retroactively reassign the Nobel Prize or rewrite the newspaper headlines from 1901. Marconi remains one of the most famous names in the history of communication technology. His face appeared on Italian currency. His name is on institutions, streets, and awards around the world. The court's decision has been absorbed into the specialist literature on patent law and the history of radio, but it has never fully penetrated popular understanding. The case is not merely a historical curiosity. It raises questions that are more urgent today than ever. In an era of software patents, pharmaceutical patents, and technology monopolies, the question of who owns an idea and whether that ownership is legitimate has direct consequences for billions of people. The Marconi case illustrates how patent systems can be gamed by those with resources and connections, how the first person to file is not always the first person to invent, and how the consolidation of credit can erase legitimate contributors from the historical record. It also illustrates something about the relationship between invention and innovation, between the person who conceives a principle and the person who builds it into something the world can use. Both matter. The trouble is that the legal and cultural systems we have built tend to reward only one of them, and not always consistently. Marconi's story is not a story of pure invention stolen wholesale. It is something more complicated and more interesting, a story of how a real but partial contribution got inflated by wealth, timing, and relentless self-promotion into a monopoly on the entire origin story of a technology. The Supreme Court in 1943 finally said, "Not quite." The truth, as it turns out, had more than one author.